Last November, 6 Democratic members of the U.S. Congress appeared in a video in which they told active service members that they had a duty to refuse to follow illegal orders. This was an accurate statement of the law. Nevertheless, Donald Trump called them traitors, labeled their actions seditious, and urged that they be hanged. Trump's ally in the U.S. Attorney's Office in Washington, D.C., convened a federal grand jury and asked them to indict the 6 lawmakers. But last week, in a rare occurrence, the grand jury refused to indict them. 2 days later, a U.S. federal judge issued a preliminary injunction against U.S. Defense Secretary Pete Hegseth, temporarily blocking him from punishing Senator Mark Kelly, one of the lawmakers who recorded the video. Some U.S. service members have refused orders to deploy to illegal wars. I was called by the defense to testify as an expert witness in the courts martial of 2 U.S. service members who refused to deploy to the Iraq War. I was allowed to testify on behalf of Pablo Paredes in the sentencing phase of his court-martial. I said that the Iraq War violated the UN Charter and that he had a reasonable belief that he would be forced to commit war crimes if he obeyed the order to deploy. Pablo was sentenced to no time in custody. But the judge did not allow me to testify for Lieutenant Aaron Watada, the first commissioned U.S. officer to refuse to deploy to Iraq. Today, U.S. service members have a duty to disobey orders to attack Venezuela, Cuba, and Iran. They have a duty to disobey orders to attack vessels in international or foreign waters. They have a duty to disobey orders to use nuclear weapons. They have a duty to disobey orders to torture or abuse civilians, prisoners of war, and other detainees. They have a duty to disobey orders to intentionally target civilians. And they have a duty to disobey orders to use military force against civilian protesters in the U.S. The duty to disobey illegal orders has its genesis in the Nuremberg Tribunal, which held Nazi officials accountable for their crimes during the Holocaust. For the first time, individuals were held legally responsible for genocide, war crimes, crimes against humanity, and the crime of aggression, which is also called the crime against peace. In its 1946 judgment, the International Military Tribunal at Nuremberg held that to initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole. A war of aggression violates the human right to peace. The Nuremberg Tribunal held Nazi leaders legally liable under the doctrine of command responsibility if they knew or should have known their subordinates would commit the crime and they did nothing to stop or prevent it. The defense of following superior orders was rejected at Nuremberg and rejected again when U.S. Lieutenant William Calley was tried for the 1968 My Lai massacre during the American War in Vietnam. U.S. military law requires servicemen to follow lawful orders, but they must refuse to follow unlawful orders. The Genocide Convention imposes responsibility for individuals who commit, assist, or failed to prevent genocide. The Rome Statute imposes individual criminal responsibility for committing and for aiding and abetting genocide, war crimes, crimes against humanity, and the crime of aggression in the ICC. The United Nations recognizes conscientious objection, the refusal to perform military service, as an aspect of the freedom of thought, conscience, and religion guaranteed by the International Covenant on Civil and Political Rights. In South Korea, conscientious objection is understood as a right to refuse conscription. This course will analyze international law provisions and jurisprudence that establish the right and duty to disobey illegal orders, the right to conscientious objection, individual and command responsibility for war crimes, crimes against humanity, and genocide, and the prohibition of the defense of following superior orders. The duty to disobey unlawful orders and the right to conscientious objection share a common normative foundation in that they both reject involvement in unlawful wars and killing. International provisions that will be examined today include the Nuremberg Tribunal decisions, the UN Charter, the Genocide Convention, and the Rome Statute of the International Criminal Court. I will now introduce our distinguished faculty for this course, and they will then begin their presentations. Triestino Mariniello is a full professor of law at Liverpool John Moores University and a member of the legal team for Gaza victims before the International Criminal Court, the ICC. He is an Alexander von Humboldt alumni at the Humboldt University of Berlin, and he has served as associate legal officer at the ICC, working on the situations in Sudan, Kenya, and the Democratic Republic of Congo. His research focuses on international criminal law, international humanitarian law, and international human rights law. And his academic writing has appeared in several leading journals of international criminal law. Triestino will discuss individual responsibility under the ICC's Rome Statute, focusing on the distinction between principal and accessories. Chantal Maloney is Associate Professor of International Criminal Law at the University of Milan and Senior Legal Advisor at the European Center for Constitutional and Human Rights of Berlin on international crimes and accountability. She received her law degree at the University of Milan and then earned her PhD in Italian and comparative criminal law. In 2006-2007, she was first visiting professional and then associate legal officer at the International Criminal Court assigned to the pretrial chamber. She was an Alexander von Humboldt Fellow at the Chair of International Criminal Law at the Humboldt University of Berlin, working on protection of the right to life in asymmetric armed conflicts. As part of this program, she spent several months in Gaza at the Palestinian Center for Human Rights. Chantal is a criminal lawyer, and she is on the list of assistant counsels before the ICC, where she also represents victims. The Minister of Justice appointed her as a member of the commission that drafted the project for an Italian Code of International Crimes. She has been invited to serve as an expert at roundtables organized by the UN and the EU Parliament. Chantal is the author of numerous scientific articles, papers, and book chapters, including the books Justicia Universale, Tragli Stati la Corte Penale Internazionale, Bilancio di una Promessa, and Command Responsibility in International Criminal Law. She is a co-editor of Domesticating International Criminal Justice and Is There a Court for Gaza? Chantal will explain why following superior orders is not a defense to the duty to disobey illegal orders. James Branham is a solo attorney in Oklahoma City who has practiced military defense law since 2006. He is a past co-chair of the Military Law Task Force of the U.S. National Lawyers Guild, and he is the author of U.S. Army AWOL, a practice guide and form book. In his legal activism work over the years, James has worked with the GI Rights Hotline, the Center on Conscience and War, Veterans for Peace, and About Face Veterans Against War. He has represented many of the public resistors to the wars in Iraq and Afghanistan. Besides the law, he is also deeply engaged in interfaith education, writing, and activism. James will address obligations in tension, international law, and U.S. military regulations. Shin Hwan-oh earned his PhD in international relations from Ritsumeikan University Graduate School of International Relations in 2016. He received his MA in International Relations from Ritsumeikan University Graduate School of International Relations 2008, and his BA in Foreign Studies from Nagasaki University of Foreign Studies in 2006. He also received an associate degree in Tourism Japanese from Busan Kyongsang College in 2003. He is a lecturer at Ritsumeikan University College of International Relations and an adjunct lecturer at Kindai University Faculty of International Studies. Shin is an expert on conscientious objection in Korea. He will discuss rethinking conscientious objection in South Korea, a shift from the perspective of human rights protection to anti-war peace movements. So our first faculty member will be Triestino Maraniello. Triestino, the floor is yours.
Thank you very much, Marjorie, for the invitation. Good morning, afternoon, evening, or night to everyone, depending on where you are. I'm speaking from Liverpool. I hope the weather is better where everyone is, better than the UK at the moment. So I'm going to focus, as has just been said, on individual liability under international criminal law. In particular, I'm going to focus on the Rome Statute, on Article 285 of the Rome Statute. The slides that you will see are just to facilitate the presentation in relation to the legal provisions that we are discussing today. I apologize in advance that I will have to leave after the presentation and a few questions because at 6 my time I have another class at university in another building where I am now. So, Article 25, and we can move on to the first slide, is the main provision of the Rome Statute dealing with individual criminal responsibility. As we've just said, the individual criminal responsibility is the pillar of international criminal justice since the Nuremberg trials. The biggest legacy of the Nuremberg trials was summarized in the few words provided in the judgment, which very simple say that behind the commission of international crimes, there are not legal entities, but individuals, not abstract entities, but individuals. Behind the commission of, at the time, war crimes, crimes against humanity, and crimes against peace, there are individuals. And so, for this reason, they should be held accountable. This is something, this principle that we take as granted before, but as I just said, it's particularly new. It's a very young principle in international law. Because until Nuremberg, only states were responsible for serious violation of international law. So the revolution of Nuremberg lies in the fact that for the first time, international law applies directly to individuals. So individuals as actors in international law, in a specific field of international law, which is international criminal law. This is something extremely important that we have to emphasize, particularly in a historical time when individuals try to undermine the credibility, the legitimacy of international institutions by arguing that the court, in this case the ICC, is trying an entire state, is trying entire population of a country. So we can hear recently saying, for instance, that the court is trying the state of Israel. Like in the past, we have heard that the court is trying Serbia or Germany or Rwanda or similar accusations, always done in order to undermine the work and the credibility of the institution. But legally and also politically, but let's focus on the legal part, this is completely unfounded, because international criminal tribunals and, in particular, the ICC, on the basis of what we have just labeled as the legacy of Nuremberg, just focuses on individual conduct. The ICC does not have any competence, as you can see in Article 25, sorry, over abstract entities, over states, corporations, multinationals, company, non-state actors. The court has jurisdiction only over individuals. This is the pillar that I mentioned of individual criminal responsibility under international criminal justice. Does this mean that states are not responsible for violation of international law that may amount to international crimes? The answer is yes. States as well may be liable for violations of international law that amount to international crimes. The clear example is provided by the Genocide Convention. So for violations of the Genocide Conventions can be responsible states, but genocide at the same time is also a crime for which individuals are responsible. It should be clarified that when we talk about state responsibility for genocide, this is a very wide concept under international law, because states can be responsible for the commission of genocide, but states can violate the genocide conventions also in other ways. For instance, by not putting in place preventive measures, so all those possible measures when they are aware that there is a risk of genocide in a specific context, like today in Myanmar and in the Gaza Strip, or when they do not cooperate in order to stop the ongoing genocide as a peremptory principle under international law, or when they do not punish, after genocide has been committed, the perpetrators. So this is just an example of state liability for a violation of international law that constitutes also an international crime. But the ICC does not have this competence. Only the International Court of Justice the maximum judicial body of the UN, can deal with state responsibility. That's an important difference that must be kept in mind. The ICJ is just has competence over states, while the ICC, as we have repeated a few times now, has competence only over individuals. So a person who commits a crime, Article 25(2), within the jurisdiction of the court shall be individually responsible and liable for punishment. A crime within the jurisdiction of the court means genocide, crimes against humanity, war crimes. In some circumstances, under some conditions, the crime of aggression as well, within a territory of a state that has ratified the statute of the ICC, the Rome Statute, or binational of a statute, unless there is a referral of a Security Council which has referred the situation in relation to alleged international crimes committed in the territory of a non-state party, like in Libya, for instance, and in Sudan, specifically in the region of Darfur. Can we move on to the next slide, please? So, Article 25(3) of the Rome Statute provides the different so-called modes of liability. In other words, different forms of individual contribution to the commission of international crimes. How individuals can participate, can provide a contribution to the commission of international crimes. In this regard, before looking, of course, I will say briefly, because for every single form of responsibility we could spend an entire lecture. This topic is discussed generally in few lectures at the university. But before looking at the individual conducts, at the individual contributions to be more precise, we should stress that the Rome Statute adopts the so-called differentiated system. What does it mean? It means that it defines, it provides, to be more precise, a distinction among the different forms of contribution. In contrast, for instance, to some national domestic systems which provide the so-called Unitarian system. Unitarian means just simply saying that everyone is responsible, independently on the specific contribution for the commission. I'm summarizing, but that's the sense of a crime. Differentiated system means trying to be more precise on the individual contribution and drawing a distinction also on the basis, like in the views of many scholars, Article 25(3) does, on the basis of the gravity. In other words, like some scholars would argue, Article 25(3) provides a so-called hierarchical, a pyramid, a hierarchical system on the basis of gravity in relation to the individual contributions. What does it mean? It means that it starts with the most serious form of the most serious mode of liability, and then it becomes gradually less, it moves gradually to less serious forms of individual participation. So, at the top of this pyramid, but before saying that, let me just add, generally speaking, that this differentiated system appear much more fair for a number of reasons, because it's more precise, it's more accurate, and in particular, it's more fair in relation to the sentencing, because in theory, then in practice does not always happen, being accused on the basis of a more serious form of responsibility of individual contribution should be also reflected then in practice in the sentencing. In other words, a person committing a crime should have, if the facts are all equal in two different cases, should receive higher sentence compared to another person who has simply, in inverted commas, aided or abetted the commission of international crime. We will see why also this distinction in relation to seriousness. Let's start from Article 25.3a. Article 25.3a, which has been subject to interpretation and application since the very first cases before the International Criminal Court. I just remind, for instance, anyone the cases against Thomas Lubanga Dailo or against Katanga. Thomas Lubanga Dailo convicted for the use of child soldiers in armed conflict in the Democratic Republic of Congo, specifically in the Ituri region. And since the beginning of the trial, of the proceedings, to be more precise, the prosecutor used Article 25.3a by arguing that, in other words, Lubanga was a principal responsible. Because that's this distinction, it's important to see the difference between principals and so-called accessories. So those ones not bearing a principal form of responsibility. So, Article 25.3a at least provides different forms of responsibility under the umbrella of the Commission. So we are talking of responsibility for the commission of international crimes. This can be direct commission, so simply an individual committing an international crime, let's say a soldier shooting a person which has a protected status under international law, a prisoner, a civilian, as an individual. So first form of responsibility in relation to commission. So the direct commission of an international crime, or jointly with another person, second form, and third, through another persons. So, in other words, direct commission, joint commission, and indirect commission, indirect perpetration. In other words, committing an international crime through someone else. So these are the three different distinct forms provided under Article 25.3a, and most debated in particular, because if on one side direct commission is quite straightforward, as we said, conduct by an individual, the problem appears particularly when it comes to the joint commission of international crimes. How do we establish who is jointly committing an international crime? On the basis of which requirements? On the basis of which theories? We can say that an individual is taking part to the commission of international crimes, and we draw a borderline compared to the case of another individual who is simply aiding and abetting the same commission, so is facilitating the commission of international crime. And as we said, should also have a different responsibility and should also have a different sentencing than at the sentencing stage. In order to establish who is jointly committing an international crime, the International Criminal Court, since the very first cases, has relied on this theory coming from German literature, and we should also have said that Article 25.3 reflects the German Criminal Court. On this basis, the International Criminal Court, and now this is consolidated jurisprudence, at least despite being also on the other side criticized, so far it's still applied by the international judges sitting in The Hague. And the theory is the so-called control theory, the theory of control over the crime, introduced for the first time, as we said before, in the Lubanga case. Which are the requirements under this theory in order to establish the so-called co-perpetration? First of all, the existence of a common plan. there must be a common plan among two or more individuals to commit an international crime. In this commission, the contribution of every single individual is essential. Essential means that without that contribution, we could say, there will not be the commission of the international crime. And this is an important difference between principal and secondary responsibility. Because in that case, the contribution could be significant, could be substantial, but not essential like in this case. In other words, people committing international crimes are so-called masterminds who are responsible. Their role in this commission is necessary. They cannot be replaced. Also because their contribution is essential, but also because each one of them has a control, a joint control over the commission of the crime, over the crime. That's why their role and presence in this regard, their contribution is essential. We can, in this regard, rely on several examples. This article has been addressed by the ICC judges in different cases. One of them that maybe you are familiar with is the situation in Kenya. The situation in Kenya was brought to the attention of the court by the Waki Commission, National Commission of Inquiry, that found out that during the so-called post-election violence in Kenya, crimes against humanity were committed in different provinces, in at least 8 provinces of Kenya. Following this report, the prosecutor, the former prosecutor of the ICC, the Argentinian lawyer Luis Moreno Campo, requested the competent pretrial chamber to start officially investigations. The authorization was granted by the pretrial chamber and the investigation started. In light of this investigation, the prosecutor asked for summons to appear against 6 individuals in 2 different cases. Among these, there were very senior leaders, including President and Deputy President of Kenya, Kenyatta and William Ruto. So, the prosecutor was explicitly relying on the article we are seeing here. In other words, Joint Commission of International Crime. And the prosecutor brought to the attention of the judges enough evidence at this stage, in other words, to prove that there were reasonable grounds to believe that they were jointly committing these crimes. That was the theory at the time. Then the cases have just collapsed because of the lack of evidence at the trial stage, after the court had confirmed the charges against at least 4 of the accused, of the defendants. So, in this case, in other words, the prosecutor was trying to prove that there was a common plan, so that in contrast to what the defense counsel were arguing, that the violence exploded suddenly, spontaneously across the entire country after the presidential electoral results were announced at the end of 2007, and the violence, the so-called post-election violence, lasted at least until February 2008. So the prosecutor arguments were exactly this. There was a common plan. In this common plan, the individuals, the accused, the 6 individuals, they were playing and they were providing an essential contribution. And this essential contribution, again, these individuals could exercise a control over the commission of international crimes. In Lubanga, the prosecution moved faster, and the idea was to apply this theory of control over the crime to indirect co-perpetratorship. So, in other words, the commission of these international crimes through an organization. This is a very important point, as we have seen before, is also reflected in Article 25.3a, and as you can see, departing from Lubanga, which will take much longer to discuss, in this case, the application of this theory of control over the crime to the specific case, is that, as you can see, Article 25 3A explicitly provides, as a form of responsibility, as a mode of liability, the commission to another individual, or like the judges will say, through an organization. What is crucial to say is exactly what you can see in Article 25 3A. Whether or not the other individual, the other person, another person is liable, it becomes irrelevant for the purposes of establishing whether the principal perpetrator is liable or not. So, in this hierarchical system of modes of liability based on the gravity, as we said at the beginning, let's move on to Article 25 3b. Just to remind everyone that this topic is also particularly important because, from a criminological perspective, these are so-called mass or massive crimes. In other words, in contrast to ordinary crimes that are generally committed by one or few individuals with one conduct or few conducts and one crime, here, when we talk about international crimes, there is a multiplicity of perpetrators, of conducts, and unfortunately, in many contexts, thousands, hundreds of thousands of victims. The second form of responsibility is ordering, soliciting, or inducing the commission of a crime. Of course, there are different conducts. For instance, ordering the commission of a crime requires the possibility to exercise an authority over, let's say, the subordinates or the people then materially committing this crime. Soliciting, persuading, inducing someone to commit this crime does not require the same authority. There must not be this relationship. Just to be clear, when I say authority, like for command responsibility, I don't mean legal authority. That can also be factual. What is important is that the individual ordering is in the factual position to order the commission of an international crime. Of course, it's also important to stress the difference between this responsibility and command responsibility. In command responsibility, there is no, the responsibility is not uh, for ordering the commission, but is for failing to prevent the commission of the crimes by the subordinates or to punish them. But I think you will come back to this also in the following presentation. Can we move on in these final minutes, please, to the next slides? And these are the final, let's say, two modes of liability under Article 25.3. So a person who is not responsible for the commission or for ordering, soliciting, or inducing may be responsible for the facilitation because she has facilitated the commission of international crime, uh, including providing the means for its commissions. What is important here is to emphasize that the commission, the so-called aiding or aiding and abetting the commission of international crimes is also very frequent in international criminal proceedings. It may happen in many ways, for instance, by providing weapons to a military group that is committing international crimes. So the conduct itself, in general, in international criminal law, is the conduct that facilitates, for instance, by providing means, weapons, training, information, and so on, to the individuals directly committing the crimes. The mens rea, the subjective element on the other side, is the knowledge that the perpetrators, the principal perpetrators are committing these crimes. So it does not require that here individuals aiding and abetting these crimes share the same intent. In other words, that they intend to commit the crimes. This is in general under international law, but international criminal law, sorry, but when it comes to the Rome Statute, a stricter approach has been adopted so far, which requires, on the basis of a literal interpretation, to include that they facilitate this commission of crimes for the purpose of committing the international crime. Maybe one of the most famous cases in international criminal justice, not before the ICC, but before another tribunal, for aiding and abetting as a mode of liability, is the case against Charles Taylor, former president of Liberia, in the famous case of so-called Bloody Diamond case, in which he was sentenced by the Special Court for Sierra Leone to 50 years. The prosecutors tried to build up the argument that Charles Taylor was the mastermind, was principal responsible for international crimes. This theory was not really very successful at the time. The judges overall they concluded, both at the trial and appeals level, that rather than being the mastermind, Charles Taylor was facilitating the commission of these international crimes by supporting in different ways the rebel groups committing international crimes in the specific context of the Sierra Leone. And the last, and I conclude very briefly because it's exactly half an hour in this moment, the last form of liability is when an individual provides a contribution which is intentional and is put in place this contribution with the aim of furthering the criminal activity or the criminal purpose of the group, where such activity or purpose involves the commission of the crime within the jurisdiction, or differently, when it's made in the knowledge of the intention of the group to commit the crime. So I'm going to stop here because just 1 minute over my time, but feel free to ask any question in relation to what we have discussed or any other issues. Thank you very much for your attention.
Thank you so much, Triestino, for explaining how the ICC's Rome Statute and also the Genocide Convention provide for the prosecution of individuals and different types of individuals, principals and accessories, and also the Joint Commission of Crimes. Very useful presentation. I just wanted to mention, following up on what you said about Charles Taylor, that the United States government also tried Charles Taylor under the well-established doctrine of universal jurisdiction and sentenced him to, I believe, 97 years in federal prison. Universal jurisdiction does not go through the ICC, but rather any country can try a foreign national for these atrocious crimes under this principle of universal jurisdiction. We have a question: if they obey the order in good faith, who will be held criminally liable? Can the commander-in-chief be held liable or the commanding general?
Well, that's a good point. I mean, this can be a defense. I think there is a specific presentation on this topic after mine, if I'm not wrong. So I don't want to spoil anything in relation to this,
Yes,
but
Chantal can address that question
this will be
if
discussed,
you'd
I
like.
think, in much
Okay.
more.
Okay,
Yeah.
I have another question. You
Sure.
mentioned aiding and abetting liability.
Yes.
Can U.S. leaders, well, first of all, we know that the ICC issued arrest warrants for Benjamin Netanyahu and
Yes.
Gallant for crimes against humanity and war crimes committed in the occupied Palestinian territory. Would you like to address why you think that they did not also charge genocide? And then a companion question is, under the Rome Statute, can U.S. leaders be charged with, on the theory of aiding and abetting, for example, genocide, war crimes, crimes against humanity, due to their provision of weapons, financial, diplomatic, and political support?
Yes, I will start from the end. So, I mean, and I fully agree. The point is, well, very timely and also correct, legally speaking. Anyone facilitating under the provision we have just seen the commission of international crimes falling within the jurisdiction of the court can be held liable for aiding and abetting. So, as the court would have jurisdiction because these crimes are allegedly committed on the territory of a state party, in this case the state of Palestine, that has ratified the Rome Statute, and transferring weapons to a state where international crimes have been or are being committed can fall under this form of responsibility, and it satisfies the two elements we have said before. No, first of all, the conduct of facilitating, which in this case is the transfer of weapons, and the mens rea, the subjective element with the knowledge that international crimes are being committed. And I mean, the conduct is admitted by the U.S. authorities. They are doing this publicly. Also recently, almost 8 billions of arms have been transferred by the U.S. to Israel. And the mens rea is also satisfied because in light of the ICJ proceedings on genocide, I'm referring to the case brought by South Africa, in light of the arrest warrants against Netanyahu and Gallant you were mentioning, no state or individual on earth can say that she is not aware that international crimes are being committed in that context. So both elements are going to be satisfied. There is just this further element that it should be discussed, and here also there are different views whether aiding and abetting requires also furthering that this conduct takes place with the intent of committing the international crime, let's say. And on the basis of how we approach this, we can also give a more precise answer. But in my views, this is not a requirement of this conduct, like it's not a requirement in common law systems, and like it's not in the other international criminal tribunals. What does this mean? This means that not only political leaders transferring weapons, but even directors of companies producing weapons who decide to, I mean, participate, if I can use this expression, at the production of weapons with the knowledge they would be transferred, sold to the specific case to Israel, could be held criminally liable under this responsibility. And there are cases, even under universal jurisdiction, I'm thinking in the Netherlands, for instance, in which individuals have been held liable for aiding and abetting in light of the transfer of weapons. Going back to the question of genocide, well, this seems to be the office of the prosecutor in this regard has always said that they are going where the evidence brings them. So it means that using the word of the prosecutor who has requested the arrest warrants, Karim Khan, we will bring cases when they have a realistic prospect of success. I'm paraphrasing, but that's the idea. So, if this has not happened yet, at least so far, it means that from these words we can deduce that the prosecutor does not believe to have enough evidence to raise charge of genocide, which, from a different perspective, appears can be seen quietly as a surprising position because as many experts, organizations, and last September 2025 have said that the Independent Commission of Inquiry of the United Nations, chaired by Navi Pillay, former judge of the International Criminal Tribunal for the former Rwanda, that has dealt with the genocide in Rwanda, there is enough evidence to argue that genocide has been and is still being committed in Gaza while we are talking. The fact that so far arrest warrants are confined to crimes against humanity and war crimes does not mean that genocide will not fall into the investigation in the future. Because as we said before, the prosecution has made it clear on a number of occasions that other crimes are being under attention and that the scope of the investigation could be widened in the future. But of course, nobody knows also because all the investigation, and that's fair, is under strict confidentiality rules. And this is an important principle at the ICC to safeguard the investigation, the witnesses, and the victims.
Okay, thank you, Triestina. One more quick question, and then we are
Sure.
going to move on to Chantal, and that is the United States is not a party to the Rome Statute. So does the Rome Statute apply to the US? It's a jurisdictional issue.
The Rome Statute applies to US nationals, of course, as we said before, not to the states. It's at the beginning, when US nationals allegedly commit international crimes on the territory of a state party, or when the Security Council refers a situation concerning a non-state party where US nationals are also allegedly involved. That is not going to happen because of the veto power by the US. So the classical context, the typical context, is the one where US nationals allegedly commit international crimes on the territory of a state party. And there is an ongoing investigation at the ICC that involves US nationals. And this is the investigation in the Afghanistan situation. Afghanistan is a state party to the Rome Statute. There has been a preliminary investigation ongoing for many years. Then finally, official investigation was open. The appeals chamber authorized the prosecutor. And this investigation concerned at least also, not only, but also US nationals, members of the army, and of the intelligence for the alleged commission of war crimes in Afghanistan, including the famous case of torture against, widely documented case of torture in the detention center in Afghanistan. The problem here is that this investigation at the moment has been frozen, is not been held as a priority by the office of the prosecutor, and nobody knows if in the future is going to produce any result. But it's just a concrete example that the court can exercise. If you read, and concluding for this, sorry for the long answer, if you read the executive orders issued by the Trump administration against almost all the ICC judges or against the prosecutor and deputy prosecutor, they mention most of the times not only the investigation in Palestine, but also the investigation in Afghanistan. Some of the judges under sanctions, they've been placed under sanctions because they were involved in those proceedings in Afghanistan. Thank you very much.
Okay, thank you so much, Triestino. We are sorry to lose you now, but that was
Also
excellent, excellent
I have another class
presentation.
in 4 minutes, so
I understand. I understand. Thank you so much.
thank you very much.
Our next faculty member is Chantal Maloney. Chantal, the floor is yours.
Thank you very much, Marjorie, and I'm very grateful for this invitation to be part again of the course organized by the People's Academy this year. I need to share the presentation with you, so let me know if it works. So...
I think it's working.
Is it? Okay.
Yes. Yes.
Okay, great. So while I'm presenting, it's a bit difficult to see you in the screen. So if you have questions or things that need to be clarified, please feel free to raise your hand. And if I don't see it on the screen, just please open the microphone in case and ask. Otherwise, in any case, we will have some time, like 15 minutes at the end for the Q&A. So as you see from the title of the presentation, what we are going to talk now is the duty to disobey legal orders and specifically the defense of superior orders in international criminal law. By the way, let me apologize for my voice. As you can hear, I got a cold and so I'm not in my best shape, but I still hope that you can follow me. And also the interpreters, let me know if I talk too fast. So let's start with a very brief historical evolution of the topic. We are talking about an issue, defenses in international criminal law, which traditionally have stayed marginal in the discourse and the practice of international criminal tribunals. As you know, international criminal law as a subject emerged in connection to the need to establish liability, so to convict perpetrators of atrocities, war crimes, crimes against humanity, genocide, aggression, in particular, of course, after the Second World War, but attempts have been done already before, after the First World War. And in the first place, the attention of practitioners and scholars has been devoted really on how to justify the conviction of individuals at the international level for the commission of these crimes. So the assessment on individual criminal liability, and not so much its opposite, the grounds to exclude liability. And in fact, in the first important international tribunals, the one of Nuremberg, the one of Tokyo after the Second World War, but also in the ad hoc tribunals that were established by the UN in the 90s, the former Yugoslavia Tribunal, the Rwanda Tribunal, there were no provisions talking about defenses, grounds to exclude liability in international, with regard to the commission of international crimes. However, in the practice of tribunals, at least one defense was invoked quite consistently. And it is exactly what we are going to talk about today, meaning the defense of superior orders. So why is it at the same time important, but also very difficult to grasp, let's say, the impact of superior order defense when we talk about individual criminal responsibility? Because, of course, international criminal law, like criminal law at the domestic level, is based on a principle of legality and the principle of culpability, meaning that from the very beginning, it was decided that only those who are individually, personally culpable, responsible for the offenses should bear the consequences of it, meaning that if a subject, a person, didn't have any possibility to act differently than what they did, so if the commission of the crime, in other words, was the only possible outcome in the situation, given the situation at the moment, the culpability principle imposes not to find that person responsible, criminal responsible for the crime, or at least in some circumstances, which we will talk about, to reduce the level, the gravity of responsibility of this person. So here there is a statement, a passage of a judgment by Judge Cassese, the former president of the ICTY, and many other things actually in his long career, who is particularly close to my studies and heart as an Italian international law professor who really spent so many years in this field and really committed, fully committed to punishing the commission of international crimes. And he noted something that I think we should keep in mind when talking about this, that is, law is based on what society can reasonably expect, there is a typo, of its members. It should not set intractable standards of behavior which require mankind to perform acts of martyrdom and brand as criminal any behavior falling below these standards. What Cassese said in these words, maybe not so self-evident, has been said also by others, in particular criminal law scholars, in expressing the view that no one can be expected to be a hero, to be a martyr, as Cassese says here, meaning that there are situations where the personal circumstances of the subject have to be taken into account in assessing their responsibility. So with regard to the topic that is of interest for us today, the question is following superior orders a defense, a possible defense, when the order that the person that committed consequently a crime was illegal? And as we will see, although we would all like immediately to have a very clear-cut answer, which is no, so following superior orders is not a defense, never when the order is illegal, we will see that the answer is a little bit more difficult and nuanced than this, even today. So let's start with a very quick recap of the fact that at Nuremberg, so the beginning, so to say, the birth certificate of international criminal law, many, of course, of the defendants, Nazi high-profile politicians, military commanders, industrialists of the German Nazi state defended themselves, tried to defend themselves, saying that they were just obeying orders. So the German expression for order is Befehl. Befehl is Befehl, meaning orders are binding, especially in a, as you can imagine, in a system like the Nazi one was, where there was a very strict hierarchy. And so they tried to exculpate themselves from responsibility, basically saying that they were just obeying orders and they were not personally motivated in the commission of the crimes. However, the judges at Nuremberg, as I said, there was no provision on this in the charter, but the clear-cut conclusion at Nuremberg is that this defense of superior orders was not recognized as valid. And among other things, judges said that a soldier was ordered to kill or torture in violation of the international laws of war has never been recognized as a defense to such acts of brutality, though the order may be urged in mitigation of the punishment. So you see a little recognition as a possible mitigating factor, but a clear-cut principle. Superior orders are not a defense when the order was unlawful, was criminal, actually. After Nuremberg, this principle was codified among the Nuremberg principles. It became Nuremberg principle number 4, that you can read here in yellow. The fact that a person acted pursuant to an order of his government or of a superior does not relieve him from responsibility under international law, provided a moral choice was in fact possible to him. So what is interesting here to note is the use of these words, of course, at the end, provided a moral choice was possible to him. And we will try now to understand a bit better what does it mean. Let me start by saying that when we talk about superior orders, we are, of course, obviously maybe dealing with an environment that is particularly difficult in the sense that we are normally talking about a hierarchical structure, normally a military structure, and in military structures, hierarchical ones, of course, I don't need to tell you how military discipline is of the utmost importance. Military discipline founded on an idea of complete obedience. And in this regard, there have been a lot of pushbacks over the years. I'm talking about hundreds of years, not just decades, of the fact that there could be any room for a personal assessment by the subordinate on whether the order that he or she has been given should be followed or not, depending on an assessment of its legality or not. And this is how a professor put it, well, a military expert actually, that it has been long considered impractical to expect a member of armed services, so a soldier, in conditions of war, so during an armed conflict, to weigh scrupulously the legal merits of the orders received. So in military doctrine, it's clear that what is expected from the military leadership, the superiors, is that they must trust that their orders will be obeyed. And this is the fundaments of the entire military discipline. At the same time, from the perspective of the subordinates, they must also trust the binding character of the order received. And in a way, this is also, from the point of view of the subordinates, a form of protection in knowing that what they have been ordered to do is binding and should be considered lawful in principle. They must also, they trust the fact that they should be able to obey these orders without having to question each and every time, especially in a difficult environment as the war environment, whether exactly they have to follow it or not. So all this just to say that there have been a lot of pushbacks about the idea that superior orders are not a defense that is possible to invoke in this environment. One of the most famous cases that I imagine all of you know very well is the trial of Adolf Eichmann in Jerusalem. And Eichmann, who was, of course, one of the highest Nazi leaders and considered to be the architect of the final solution after the Wannsee Conference close to Berlin, where the Holocaust, the way the final extermination of the Jews, the system of the trains and the gas chambers and so was in practice designed. He was put, as you know, at trial in Israel after being kidnapped in Argentina in 1961 and convicted to the death penalty. His trial is very interesting. All the documentation is very interesting. And the entire defense of Eichmann was revolving around the idea that he was not personally anti-Semite, motivated. He had no interest in committing any kind of, and he had also no intent, what he claimed, against the Jewish population of occupied territories under German Nazi rule. But he was, and this is what he said, there is a need to draw a line between the leaders responsible, and the people like me forced to serve as mere instruments in the hands of the leaders. So he tried to portray himself as just a mechanism, just a tool in a bigger machine that was executing orders without having any real decision making in the system. Of course, it's a little bit broader than what we are talking about, the superior orders, but it touches the same critical, in the end, points. The court, of course, didn't buy Eichmann defense. They found that not only was it not only a small gear in the machine, he was actually in a leadership position that made others actually comply with this genocidal system, but also, again, this is one of the situations where the defense of superior orders was absolutely dismissed as having any kind of impact on the responsibility of individuals that committed grave atrocities like the case at stake. But despite the fact that, as I said, in theory, we all agree that defense of superior orders should not play a role. For a long time, the doctrine and the theories diverged in this regard. And there was, for at least hundreds of years, until the Second World War, I would say, until Nuremberg, the main principle was the opposite, was the principle of respondeat superior, meaning in Latin, the superior is the one responsible. So superior orders were considered to be a defense for the subordinates that completely excluded criminal liability on the part of those subordinates who acted upon orders. And again, the stress here, the focus was on obedience, the aim to ensure obedience. Then we can see an opposite principle, position developed, the one that we can call absolute liability. So according to this position, the fact that the perpetrator, so the subordinate, committed the crime under orders does not affect his or her liability. So in this case, as we have said now with regard to Eichmann or the cases regarding the Second World War, it doesn't matter when the person was acting upon orders, the defendants were all convicted, and at the best, there might be a little mitigation of the punishment. And then there is a third variation of the principle, which is called manifest illegality. This is a bit an intermediate, a compromise solution, in the sense that it postulates that superior orders can, in some circumstances, exclude the criminal responsibility of the subordinate, but only if they were not manifestly unlawful. And of course, if the perpetrator did not know that they were unlawful. So let's try to substantiate a little bit better these positions. And an important case I wanted to mention was decided in the 90s by the Tribunal for the Former Yugoslavia, the ICTY. So in the case of Erdemovic, that we will see now, we notice how this defense of superior orders, having acted upon orders, is very close to another form of defense, which is called in criminal law duress. And the defense of duress basically is an enhanced form of superior responsibility, which is exactly what we were talking about when we said that in Nuremberg there was this idea of a moral choice. So the defense of superior orders does not exculpate the subordinate from the commission of, from responsibility for the commission of the crimes, given that a moral choice was possible. So in this case of Erdemovich was a soldier, a young soldier that was in the Bosnian Serbian army, and he was involved in the conflict, of course, in the former Yugoslavia, and was forced to shoot at innocent people under threat of his own life. This happened in a very complex scenario where this young soldier himself was in a platoon and he was given this order to shoot them. And when he refused, he was threatened to be killed himself or his family. So Erdemovich pleaded guilty in front of the tribunal and acknowledged that he had shot innocent civilians, and he did so because he felt he did not have any choice. And the tribunal, in particular, then confirmed by the appeals chamber, decided that still Erdemovich had to be convicted because duress cannot be invoked as a defense when the person committed crimes like war crimes or crimes against humanity involving the killing of civilians. So even if the defendant, as I said, in a way acknowledged that he didn't want to, and he was feeling compelled, and this was also confirmed that this was the situation, still the judges decided for his conviction. There was one dissenting opinion by Judge Cassese who, a little bit on the same lines of what I was telling you before, reasoned about the fact that it's not possible to ask everyone to be a hero. And the law should not oblige someone to come to the point of losing his or her own life in order not to commit a crime. And so, in his opinion, at least a mitigation of the punishment should have been granted to Erdemovich. But this is also a major divide between common lawyers and civil lawyers, because in common law, the killing of innocent civilians it can never be exculpated completely by the defense of duress, while in civil law, like the Roman Germanic system where I come from, for instance, there is a room for that. In any case, this is the conclusion of the appeals chamber. Erdemovich was convicted, a little mitigation of punishment was given, and this remains as one of the most important examples that tell us that superior orders, even when they amount to the defense of duress, are not valid excuse in front of killing of civilians. And another confirmation of what we are saying comes from the commentary of the International Committee of the Red Cross, that probably you know is the depository of the Geneva Conventions, so the most important instruments regulating armed conflicts with regard to superior orders. So in the very big work that the ICRC has carried out over the years, basically the committee has commented on the entire set of rules of customary international law when it comes to IHL. And one of these rules is the one that you can read in this slide, Rule 154, obedience to superior orders. And this rule, as formulated by the ICRC, states every combatant has a duty to disobey a manifestly unlawful order. So you see, it is interesting that the title is obedience to superior orders, but the rule, as it has developed and is now acknowledged to be customary law, thus binding on everyone, is not talking of obedience, is talking of the opposite. So we have now developed a rule in the sense of disobedience. And this must be very clear. There is a duty to disobey. To disobey what? A manifestly unlawful order. So it is also important to be precise. Not every unlawful order triggers this duty, but the manifestly unlawful one. And so there is a link to this provision that I put in the next slide. You can open it at home, of course, and read better. But in the ICRC database, so you can find many interesting things, including case law and so on, and then explanation of what is meant by manifestly unlawful orders. So in this sense, it must be absolutely considered as now something clarified that subordinates, soldiers that commit crimes, in particular international crimes, war crimes, pursuant to an order which is manifestly unlawful, cannot be exculpated. And on the contrary, there is a duty to disobey these manifestly unlawful orders. And this is confirmed by the following rule, that is Rule 155th, that is called defense of superior orders, that says clearly, obeying a superior order does not relieve a subordinate of criminal responsibility if the subordinate knew that the act ordered was unlawful or should have known because of the manifestly unlawful nature of the act ordered. So it's said in a way that maybe it's not so clear. We will see now the ICC Rome Statute in a way adopts the same rule, maybe in a more clear way. But this is the conclusion. On the one hand, there is a duty to disobey manifestly unlawful orders. On the other hand, the defense of superior orders cannot relieve the subordinate from responsibility for having committed a crime when obeying manifestly unlawful orders, or if the subordinate knew that the order was unlawful. So here the last 2 minutes really of my presentation. I want to come to the Rome Statute. So what is the solution that was adopted in Rome in 1998 with the adoption of the Rome Statute of the International Criminal Court? So you, I guess, are understanding, you grasp the difficulty of this topic, how it was loaded with also moral debate and different opinions coming from different traditions. And for the first time, compared to past statutes of international tribunals, like I mentioned, the ad hoc tribunals, and of course before Tokyo, Nuremberg, but also others that didn't have any provision on defenses, for the first time the Rome Statute includes detailed provisions of a number of defenses, meaning grounds to exclude liability. Some of them are listed in this Article 31.3, and I just outlined them here for you. We're not going to talk about them. And then there is Article 33, which is specifically on the superior orders. So if you take, sorry, I wanted to read it to you, Article 33, maybe, I don't know if any of you have the Rome Statute, but the text of the article says, the fact that a crime within the jurisdiction of the court has been committed by a person pursuant to an order of the government or of a superior, whether military or civilian, shall not relieve that person of criminal responsibility unless A, the person was under a legal obligation to obey orders of the government or the superior in question. B, the person did not know that the order was unlawful. And C, the order was not manifestly unlawful. And then there is a last comma that says, for the purposes of this article, orders to commit genocide or crimes against humanity are manifestly unlawful. So in the slide that you have in front of you, I try to summarize a bit this, and what comes out clearly from this provision is that if you want to make it simpler, orders to commit genocide and crimes against humanity are always manifestly unlawful. So what remains, apart from aggression, which was not mentioned, and it is a little bit different because it is a leadership crime, so I'm not talking about that now, but war crimes are the only context in regard to which the defense of superior orders can be invoked, and it has a very narrow scope, the defense, because you need to have these three cumulative conditions: the legal duty to obey the order, that the person did not know that the order was unlawful, and that the order was not manifestly unlawful. Only when all three of these conditions are met, superior orders can have some value, let's say, in exculpating or at least mitigating the responsibility of the subordinate. And the last slide, so basically to say that this solution as adopted in the Rome Statute is contested. Not everyone is happy with that. As we have seen, there are reasons why this compromise solution was adopted, and there is a limited recognition of the defense of superior orders. But there are many scholars, and I would be part of them, that argue that superior orders, when we are talking about the commission of international crime, should never play a role. And the fact that a subordinate has executed, obeyed an unlawful order should always be considered as a manifestly unlawful order, also vis-a-vis the commission of war crimes. Maybe the only reason why war crimes are not considered to be manifestly unlawful always is that if you read the catalog of war crimes, indeed, among them, there are some crimes that could be contended are not always so manifestly unlawful, like it is in the case of course, genocide and crimes against humanity, because there are, for instance, some war crimes against property, or so that require a little bit more of understanding. Having said that, I think we can for now close it here. I'm very happy to take your questions and maybe also try to adapt this to concrete situations if you have some questions about it. Thank you very much.
Thank you so much, Chantal, for detailing the fascinating genesis of the defense of superior orders. I had no idea. I knew about the Nuremberg principle, which has carried forward to cases during the Vietnam War, for example. But the contours are just really, really interesting. Respondeat superior, absolute liability, manifest illegality, and its connection to duress, the duress defense. The Nuremberg standard, is there a moral choice available? And the International Committee for the Red Cross rules, and then now how all of that has been included or refined in the Rome Statute. So thank you so much for that. We have a question: if they obey the order in good faith, who will be criminally liable? Can the commander-in-chief be held liable, or the commanding general?
So in any case, the person who gave the unlawful order, the commander, is responsible. So, of course, when we are talking about the commission of international crimes like the ones we are talking about, you always have a multi-layered responsibility, right? I studied for many years the issue of command responsibility, which is the perfect example to show how you can go from, those who are the soldiers on the field that are actually close to the commission of the crime to not only the military commanders that are remote, that are not close to the commission, but they could and should have controlled what the soldiers were doing, to even the political leadership. So in some cases, of course, we have already examples of Minister of Defense or even Prime Minister, the cases that we are seeing in front of the ICC, Netanyahu and Gallant, right? They are responsible for the crimes committed on the ground in Gaza. So having said that, we have a multi-layered system of responsibility. Trestino spoke before about the various modes of liability. It's a complex issue. The superiors remain responsible. The point is, my presentation is only today about the perspective from the subordinate, the one who received the order. And you say, what happens if he is or she is in good faith? As I said, good faith is not enough. You must have the three conditions cumulatively present. The order was binding. It was not known by the person, so good faith, that it was unlawful, and it was not manifestly unlawful. If all three of them are present, there is space to say maybe this person is not responsible, or her or his responsibility should be diminished, mitigated. Otherwise, the person remains responsible as well as the superior. We don't hear you, Marshall.
Sorry, I was muted. Yes, thank you for that explanation, Chantal. There is a question, basically, a subordinate, when faced with a decision whether to follow an illegal order, is in what we call in the US a catch-22 situation. They're damned if they do, they're damned if they don't. If they obey the order, they can be criminally liable for following an illegal order under international law. If they disobey an order, they will be court-martialed in the US anyway, and then they're at the mercy of the judges. So where does that leave someone who is faced with an illegal order?
Yeah, if you go to the database of the ICRC that I used in the slides before, there is an interesting rule after the one that I showed that is exactly talking about this. What happens if the order is not manifestly unlawful, but just unlawful. So in that case, what the ICRC at least says in their recognition of what is customary law by now, so beyond the US, of course, is there is no duty on the subordinate to disobey the just unlawful, not manifestly unlawful order, but at the same time, a subordinate, a soldier that has disobeyed an unlawful order shall not be punished. So that shouldn't be a ground for a court martial to find a subordinate, insubordinate exactly, and punish them. This at least is what the database on customary international law says. Then, of course, it's another question whether at the national level, according to the state-owned national military doctrine and its own practice, which kind of rule will be followed. But from the international law point of view, a subordinate that disobeys an unlawful order should not be punished.
Yes, thank you for that answer. And that will, our next presenter will be James Branham, and he is going to speak about the contradiction between international law and U.S. military regulations. So I think that, that will be very useful coming after your presentation. I did want to say one thing, and that is you mentioned the trial of Adolf Eichmann in Jerusalem. That was under the doctrine of universal jurisdiction. Which means that even if there's no connection between the perpetrator and the country trying that perpetrator, and in this case, there was no direct connection between what Adolf Eichmann was accused of doing in Germany and other parts of Europe and Israel. Nevertheless, because of his atrocious crimes, he was tried by Israel, convicted, and hanged under the well-established principle of universal jurisdiction. And I think that's something that people should keep in mind, especially now in situations where perhaps the ICC would not have jurisdiction. Other countries would have jurisdiction under the universal jurisdiction. We have,
Thank you so much.
Yes. You have to go?
I have to go,
Yes.
but thank you so much again.
Thank you, Chantal. Thanks so much. Fascinating presentation, and hopefully we'll see you again in the future. Take care. Bye-bye. Next, we have James Brannan following very logically on the heels of Chantal's presentation. So James, the floor is yours.
Well, thank you so much. It is a great honor to get to speak here today. I am a practicing attorney here in the United States. I primarily work as a civilian lawyer, but in the military system of justice on the defense side of things. And so because of what I do, I normally do not get to engage in this kind of broader theoretical analysis. So I'm really excited to get to do that today. And I'm hopeful that my remarks might be helpful in considering the ways that international law principles are interpreted and applied in the practical context of the U.S. military. We have heard previously from Triestino and Chantal that international law imposes a duty on individual military service members, that they must follow the laws of war. There are principles found in the Rome Statute, the Geneva Convention, and other places that make it clear that there are boundaries that must be followed, and that it is not enough to say, I was given orders, I'm just following orders. No, international law makes it clear that that alone is not a valid defense. The challenge, though, we face here, as in many other areas of law, is on the question of remedies. In other words, just because a law is enacted, just because a law says a certain kind of conduct is forbidden, so what? What happens if the person violates those rules? What is in place to actually enforce these laws and principles? And that gets very tricky, particularly in the context of international law. The problem we have with international law is the complexity that is added by the concept of national sovereignty, which means that many nation states have been able to insulate themselves and their warriors from responsibility for violation of the laws of war. The weaponization of national sovereignty is an ongoing issue, but it's especially so for nation states that refuse to consent to the jurisdiction of the ICC, International Criminal Court, most notably the United States of America. In light of this jurisdictional gap, today will be discussing the current state of U.S. law as it relates to the laws of war and the very limited protections available under U.S. law for service members who have been given illegal orders. This discussion will be practical in nature, rooted in part on the circumstances of my clients, the conversations I've had with service members facing very immediate questions in front of them. What should I do? And so this is not purely theoretical, but rather I'm going to be discussing it from a theoretical standpoint, but it is rooted in the actual experiences, lived experiences of service members. Along with, though, unpacking this, showing what we're dealing with, I'm also going to be talking a little bit about what we can do to fix this jurisdictional hole and what can be done to ensure that the most powerful nation state on earth is subject to the same laws of war as every other nation. So I'm now going to share screen for this next part because we're going to look at a few laws. And we're going to begin with the UCMJ, the Uniform Code of Military Justice, Article 90. By the way, all of the resources I'm sharing today, they're going to be included in the handout I think y'all are getting later with a whole list of resources. But this particular, actually all of the legal citations here are all found in the same document, the Manual for Courts Martial. I have a link here to it, but again, you'll get that in the handout as well. And again, I can't say enough about the Manual for Courts Martial because it really provides a whole lot of important resources. But inside of that, in the UCMJ, which is the primary statute under federal law, U.S. federal law that governs the military, let's read Article 90. It says, any person subject to this chapter who willfully disobeys a lawful command of that person's superior commissioned officer shall be punished. 1, if the offense is committed in time of war, by death or such other punishment as a court-martial may direct. And 2, if the offense is committed at any other time by such punishment other than death as a court-martial may direct. Now, a few things I should say about this provision here. First of all, the UCMJ itself functions as a federal statute. And in the U.S., under the legal system we have here, there is a hierarchy or tiers of laws. At the top is the U.S. Constitution. Below that are federal statutes and treaties. They both are at the same level, right below the Constitution. Anything below that in the tiers, which are regulations, they cannot contradict that second tier, statutes and treaties. In the same way, statutes and treaties are subordinate to the U.S. Constitution. And so there is a tiered thing. In this, under this tiered system, the UCMJ is very near the top. The only thing that puts a check on it is the U.S. Constitution. Now, if we're looking at Article 90, and also I'll mention for U.S. folks, the provision that specifically says that treaties have the same co-equal status as federal statutes is the Supremacy Clause of the U.S. Constitution, Article 6, Clause 2. So looking at the UCMJ, understanding that again in the tier system, it's very high. It is second only to the Constitution in its function. There's one word in this provision that is key, and that is the word lawful. So if someone who willfully disobeys a lawful command can be punished. Note, though, we're not given a definition of law. And so for that, we have to go to some other places. And so continuing onward, let's look at our next slide. This is from RCM 916 Delta, or Rule for Court Martial 916D, which is part of the Manual for Courts Martial. Now, while this is all found in the same big document, this particular RCM functions in that third tier. So it's not, it is below the UCMJ. It is a regulation. So this gives commentary. It fleshes things out. It also provides procedural details. So let's look at RCM 916 Delta. Here's what it says. Obedience to orders. It is a defense to any offense that the accused was acting pursuant to orders unless the accused knew the orders to be unlawful, or a person of ordinary sense and understanding would have known the orders to be unlawful. Discussion. Ordinarily, the lawfulness of an order is decided by the military judge. See RCM 801 Echo. An exception might exist when the sole issue is whether the person who gave the order in fact occupied a certain position at the time. An act performed pursuant to a lawful order is justified. See RCM 916 Charlie. An act performed pursuant to an unlawful order is excused unless the accused knew it to be unlawful or a person of ordinary sense and understanding would have known it to be unlawful. Now, a few things here we can learn from this RCM. Again, this is interpreting the UCMJ here. First of all, knowledge is a key element. In other words, a person has to, service member who's facing this must either know that the order is unlawful, or it must have been so obvious that any person of ordinary sense of understanding would have assumed the order to be unlawful. Also, very important, this line here, ordinarily, the lawfulness of an order is decided by the military judge. This is deeply troubling for a lot of reasons. One of them is that a military judge is not a civilian. Rather, a military judge is going to normally be a higher ranking military official, normally at the lieutenant colonel or colonel level. So that'd be like 05, 06. And so fairly high ranking, but they are part of the system. They previously were likely a JAG lawyer, meaning they were either a prosecutor or a defense attorney in the military prior to becoming a judge. But this is someone who is embedded in the system, who is a part of the system. They may be under a different chain of command. There may be some protections, but still they are part of the system. And that person is charged with deciding whether an order is lawful or not. So let's continue on down. Our next slide this is from some of the commentary on UCMJ Article 90. It's also found in the Manual for Courts Martial. By the way, I'll mention that when I say commentary, I'm not meaning this is like commentary written by some other. This is actually official commentary. It is from the Department of Defense, U.S. Department of Defense. So it does have some binding elements to it, yet it still is subordinate to the actual statutory language itself. So let's look at this commentary on UCMJ Article 90. It begins as follows. I. Inference of lawfulness. An order requiring the performance of a military duty or act may be inferred to be lawful, and it is disobeyed at the peril of the subordinate. This inference does not apply to a patently illegal order, such as one that directs the commission of a crime. Before I go on, I'm going to mention here that line, it is disobeyed at the peril of the subordinate. We're going to come back to that, but I just want to highlight that because that is a key concept throughout this question in the U.S. military law context. The risk is all on the individual service member. Disobeying an order is at their peril. They have to be making the right call. So continuing onward. I. Determination of lawfulness. The lawfulness of an order is a question of law to be determined by the military judge. Before I go on, I'll mention that in the U.S. legal system, we often speak of questions of law versus questions of facts. Questions of law are normally decided by a judge. In other words, it's deciding what is the law here, what is the binding principles. Questions of fact are decided either by a jury or in some cases by a judge in determining what happened. So the problem is that even if a service member is facing charges for disobeying a lawful order, and they say, I want to be judged by a court-martial panel, which is military speak for a jury, the question of illegal orders will not be decided by that jury. It will be decided by the military judge. And that is very problematic, to say the least. Okay, continuing on. III. Authority of issuing officer. The commissioned officer issuing the order must have authority to give such an order. Authorization may be based on law, regulation, custom of the service, or applicable order to direct, coordinate, or control the duties, activities, health, welfare, morale, or discipline of the accused. IV or 4. Relationship to military duty. The order must relate to military duty, which includes all activities reasonably necessary to accomplish a military mission, or safeguard or promote the morale, discipline, and usefulness of members of a command, and directly connected with the maintenance of good order in the service. The order may not, without such a valid military purpose, interfere with private rights or personal affairs. However, the dictates of a person's conscience, religion, or personal philosophy cannot justify or excuse the disobedience of an otherwise lawful order. Disobedience of an order which has for its sole object the attainment of some private end, or which is given for the sole purpose of increasing the penalty for an offense, which it is expected the accused may commit, is not punishable under this article. And 5. Relationship to statutory or constitutional rights. The order must not conflict with the statutory or constitutional rights of the person receiving the order. So let's unpack this a little bit. First of all, we talked here, again, we still have this, this inference of lawfulness. In other words, what we're saying here is that the system is saying that if a military official gives an order, and they are authorized to give such orders, in other words, someone in your chain of command, then it is inferred that the order is lawful. It's not questioned about whether the order is lawful or unlawful. In other words, the burden of proof is 100% on the shoulders of the defendant. And as we discussed a moment ago, also the decision of whether an order is lawful or not, that adjudication is done by the military judge alone. And bear in mind, there's another big problem. If the military judge is the only person who can make the call, is it possible? The obvious question is, well, what can a service member ask for an advisory opinion? Is there some process you can say, hey, I've been given an order to do X, Y, and Z. I think it may be unlawful. Can you give me expert guidance on that? That does not exist. Certainly a member of the military could reach out to an attorney. They could reach out to JAG, and they may or may not get an answer from them. But it would be in no way a binding opinion. It would simply be just that, an opinion. And also bear in mind that you can't even go call up the military judge. You can't make an appointment to go see the military judge, because in the U.S. military, courts martial do not exist until they have been convened into existence, normally by a very high-ranking military official. In most cases, that's going to be a general or an admiral. In most cases, it's going to be the base commander. Sometimes it can be delegated to a lower level of the chain of command, but most of the time, it's going to be at a very high level called the convening authority. And so bear in mind, the court doesn't really exist. So you get this whole corps of judges out there, but they're not sitting in office until the court gets convened into existence. And it's only when they're convened into existence so they even have the authority to make a ruling on the lawfulness or of an order. In other words, all of the risk is on the service member to make the call. They are effectively being expected to have the knowledge of an attorney to make this call. And most of them obviously are not attorneys. Now, there are, thankfully, in this provision, this regulation, this commentary here, there are some helpful limitations, though. First of all, in order for it to be lawful, must be related to a valid military duty. And some practical examples are that if a commander And this is happening in the United States right now, that members of the military are being ordered to attend chapel services of a certain religion by their commanders. That is patently illegal, violation of the First Amendment's Establishment Clause. And also, in this case, the commentary says the order must not conflict with the statutory or constitutional rights of the person receiving the order. So in other words, if a commander is attempting to enforce someone to attend a certain church, that would be a problem. If a commander is telling a service member for their off-duty time that they're not allowed to speak to the press, they're not allowed to engage in free speech actions. Outside of some very limited circumstances, military commanders cannot do that. And so this limits, so those would be clearly unlawful orders, and the regulations do make it very clear about that. Also, a commander to give an order must be in the appropriate position, meaning a random commander can't just walk up to a random service member and order them to do X, Y, or Z just because of their rank. They have to be in that service member's chain of command. In other words, that whole command structure that goes all the way to the commander-in-chief, if it's someone in that chain of command who has that authority, they can give an order. If it's some random military official, they cannot. So with those understandings in place, let's now talk a little bit about some of the practical issues here. Because in practical terms, individual members of the U.S. military face a terrible set of choices when given illegal orders. So here are those choices. First of all, the service member could refuse to obey the illegal order. So let's talk about what would happen if they do that, or what could happen. And the key word here is could. There's a lot of unpredictability currently in the U.S. military. What's possible and what's likely are two different things. But what is possible? First of all, a court-martial prosecution, which could result in imprisonment and other penalties, including the loss of one's pension that they might otherwise have been entitled to, as well as the loss of other civil liberties due to having a criminal conviction on one's record. It can have serious life-altering impacts upon someone, depending on what level of a court-martial is done and what the exact punishment is, but it can be very serious. Secondly, disobeying an unlawful order could result in administrative proceedings that could result in the reduction of rank, fines, or even being kicked out of the military. One thing I will mention here is an administrative proceeding happens instead of a court-martial, which means that someone could be punished through an administrative procedure, and they could raise the issue, but this order was unlawful. What is the commander going to do in that case? The commander is going to say, I can't rule that this is unlawful or lawful. The regulations say it's up to the judge, and we're not in a court martial. So tough cookies, you're being punished. In other words, by putting it in this administrative arena, often it allows the military to do very serious punishments against someone without putting them through a court martial. And again, the problem here is that this effectively means the issue of illegal orders is very, very difficult to raise outside of a court martial. But there are other dangers. Another serious danger for many members of the military is if they disobey an unlawful order, they may face serious harassment or even the risk of violence from their peers, their fellow coworkers. And again, I would just say in the context in the military context, everyone is really amped up. Everyone is very, some people are really gung-ho about the mission that they're being told to do, even if it's illegal. There can be serious interpersonal conflicts that could result because someone says, I can't do it. Finally, the most common outcome from an illegal order, refusing to obey an illegal order, is uncertainty, which can lead to profound issues, including in time mental health issues. And I've seen that from my clients. I've seen them when they're not given a clear answer about what's going to happen next. And they're afraid, maybe I'm going to go to jail. Maybe I'm going to be kicked out of the Army and lose my retirement. Maybe something else or maybe nothing is going to happen. That uncertainty can be very unnerving. So those are the practical, real-world consequences of disobeying an unlawful order. What about obeying the unlawful order? What are the consequences of that, though? And that is also very important for us to discuss. First of all, The most important and most serious, long-lasting consequence of obeying an unlawful order is moral injury. That means guilt. That means shame. It can even result in post-traumatic stress disorder, PTSD. If you look at some of the research about PTSD, the elements of moral injury is sometimes the most corrosive thing that fuels PTSD. That sense of moral incongruence with one's own philosophy, one's own personal what's deep down inside compared with what they are being asked in order to do. For those who choose to obey the illegal order, often it does result in serious issues of moral injury. Also, obeying an unlawful order consequently means harm to others, particularly in the context of an illegal war. In other words, we're talking about those who are on the other side of the conflict, those who are who are the targets, but also those on the sidelines, or theoretically on the sidelines, but who the bombs are hitting their homes too. In other words, that participating in obeying the illegal order can result in that. Also, obeying an illegal order could result in the potential of prosecution in the future under either U.S. law or more likely under international law, particularly if the service member is traveling outside the United States. By the way, that is not a theoretical risk, as some veterans of the IDF, Israeli Defense Forces, have discovered when they've traveled overseas. In other words, just because the U.S. doesn't consent to ICC jurisdiction, a lot of other countries do, and a lot of other countries are even willing to use principles such as universal jurisdiction to bring those who commit war crimes to justice. So, all this is to say is neither of these sets of choices are great choices. Both of them have serious risk, serious complications, and life-altering context. So in concluding, I'm going to discuss some short-term remedies, short-term responses, and then some longer-term responses. In the short term, it is critical that U.S. service members be fully informed of the risk of both obeying and disobeying illegal orders. And it is imperative that members of the U.S. military have access to the resources they need to make the best decisions possible. And I'm going to take a moment here to share the screen. And this slide I'm showing, the information on it is also on the handout you'll be getting later. But these are organizations that can be helpful to a member of the U.S. military facing these questions. They include the Military Law Task Force, the National Lawyers Guild, the Orders Project of the National Institute for Military Justice, GI Rights Hotline, About Face Veterans Against War, Center on Conscience in War, and Veterans for Peace. These are organizations that I have a lot of confidence in and are organizations that have been very helpful to folks facing these questions, not only in sorting through the legal issues, but also some of the personal issues, and also helping them to be connected to a broader movement as they're working through these issues. And so strongly recommend connecting service members with these resources. In the long term, though, from an international perspective, and again, one of the great privileges being participate in this today is having people from all over the world who are participating. And so for those of you who are not in the U.S., I'm encouraging you, there are some things that you can do as well to help. First of all, we need to put pressure on other governments around the world to be ready to investigate and prosecute individual U.S. military service members, but especially high-ranking officers who are the most culpable. And then they need to be ready to prosecute them when they travel overseas. This is imperative. If this doesn't happen, there's going to be almost no accountability. And so it's important that countries around the world take seriously their responsibility as participants in the international community to bring those who have committed wrongs to justice. Also, for those of you in the United States, it's our job to put pressure on our government to consent to ICC jurisdiction. This is something that it's inexcusable that our nation, which likes to pride itself on being a bastion of freedom and liberty, of being this light upon the hill and all this other malarkey, the reality is that if we don't consent to ICC jurisdiction, we're saying that the laws that govern the rest of the world do not apply to us. These principles that were hard fought And again, we think about the aftermath of World War II, when the world community came together to say, there has to be some boundaries, there has to be some standards. All of that structure being put together to bring the wrongdoers of the Nazi regime to justice, if it doesn't apply to the US as well, it's meaningless. And given the immense power and might of the US military at this moment, it's imperative that the US be held to account just like every other nation. So I'm going to go ahead and end it there, and we'll move into, I think it's a good stopping point.
Well, thank you so much, James, for explaining the contours of U.S. military regulations on unlawful orders, their binding effect, and how they interact with each other, and also for detailing the legal and practical consequences of either obeying or disobeying an unlawful order, and also for explaining the remedies. Thank you so much for that. I think it probably makes sense to take that we do have a couple of questions, to take a couple of questions now, responding to your particular presentation, and then we can move on to Shin's presentation. So first of all, who determines that the military mission is itself unlawful? For example, I've testified as an expert in saying that the war in Iraq violated the UN Charter. Who makes those determinations ultimately?
Well, under U.S. law, there is not anyone to make those determinations. Theoretically, a military judge determines the lawfulness of an individual order. I don't think there is any provision under current U.S. law to judge an entire war to be illegal, other than to take the principle of the military judge having the power to adjudicate whether a particular order is unlawful. And so I think there could be that argument. Beyond that, under current law, that doesn't exist. We do not have a clear-cut way of determining under U.S. law whether a war itself is lawful or unlawful. I would point to the UN Charter as being a great place to start if we had the structure to do this, because the UN Charter makes it clear what wars are lawful and unlawful. The U.S. has signed the UN Charter, and hence it is binding law in the U.S. theoretically. Practically, judges tend to not go there. And I have raised these issues in military courts martial of questioning the actual legality of a war, and it goes nowhere, unfortunately, currently.
Okay, well, that is unfortunate, and Congress certainly can pass laws declaring that things are unlawful. Whether they do that or not is another. It's another issue, of course. What about other jurisdictions? We've talked a lot about U.S. law and regulations and how they interact or conflict with or contradict international law. What about other jurisdictions such as national laws in Africa? I don't know if you want to deal with that, but I do know that the Banjul Charter, which is the African Charter on Human and People's Rights and Duties, actually, does not specifically deal with the defense of superior orders. Customary international law has codified the Nuremberg standard, but different African countries, I correct me if I'm wrong, and people can weigh in the chat on this, but different African countries would have individual laws, but they generally follow the Nuremberg rule, which is reinforced in the statute of the special statute of the court for Sierra Leone. Do you want to respond to that, James?
I wouldn't have a whole lot to respond on that, other than to say that I think there's a lot that could be done in other countries. I mean, one of the main issues is if you have a U.S. service member or even the U.S. government as a whole that is the wrongdoer, what remedies are available in different countries to pursue justice? And I think there are. I mean, I'd say it another way. The U.S.'s decision to not be a part of the ICC jurisdiction doesn't change the fact that other countries do have jurisdiction. And again, the principle of universal jurisdiction has been invoked, and we've talked about in the context of the past Nazi war crime trials. I'm also thinking about some of the cases in Spain in particular that have also asserted universal jurisdiction over war crimes. And so I think a lot of possibilities. But practically speaking, when the U.S. government is the wrongdoer here, it's, the question is what the law might be and what they get away with based on might are two different things.
Are you aware of any judicial remedies such as habeas corpus if a service member is imprisoned for following unlawful orders or refusing unlawful orders?
It is possible to do what's called a collateral attack, which is where you're bringing in a federal district court, that's the lowest level, the federal court system, to challenge something, basically to use habeas to bring it into that court. Theoretically, that's possible. Practically, it's nearly impossible. There is a great deference that the civilian courts have in the United States towards the military. And so because of that, a very, very small number of such challenges ever get taken up. So it is possible, but extremely unlikely they would actually happen. And I'm not aware of any habeas challenges involving illegal orders in recent years. I know there's been habeas challenges on other things, such as for instance, a conscientious objector who was denied their due process rights. There have been cases, successful cases on habeas review challenging that. I'm not aware of any habeas challenges regarding illegal orders themselves.
And what about holding governments responsible for refusing to arrest and prosecute soldiers of another nation under universal jurisdiction when their crimes have been brought to the attention of the authorities?
Absolutely. That can and should happen. Absolutely.
Okay, and then just one final question, and then we'll move on to Shin's presentation. Can you address the due diligence standard in international cases where a corporation has committed hazards to a country or a whole society? And I would venture to say, refer people to the International Court of Justice advisory opinion on climate change, which held that states have a responsibility to prevent and not contribute to climate change. Do you want to add anything to that, James?
I don't. Unfortunately, that's a little bit out of my area of expertise.
Okay, well, thank you so much. Just so useful and comprehensive, and I learned a tremendous amount, and I know other people did as well. So thanks again for that.
Thank you.
Next, we are going to move on to Shin Hwan-Oh. Shin, the floor is yours.
Okay, thank you. Hello, everyone. It is my honor to a presentation in here. My name is Hyun-Oh Shin. I'm a lecturer at Ritsumeikan University in Kyoto in Japan. Okay. I'll be sharing my materials. Okay. Marjorie, do you check my
Yes,
my
I
slide?
see it. I see it. Yes, fine. Thank you.
Okay, you're welcome. Okay, I will be continue. My presentation its title is Reconciling a Conscious Objection to Military Service in South Korea from the aspect of guaranteeing human rights to the aspect of the anti-war peace movement. Today, I would like to examine conscious objection in South Korea, not only as an issue of individual right, but also as a broader movement toward peace and the prevention of war. In particular, I will explore how the concept has evolved, what constitutional and legal challenges remain, and how it can contribute to peace in East Asia. Okay. Okay. And next is I will explain my presentation contents. Today I will divide my talk into 8 parts. First, I will explain the scope and limit of conscious objection in South Korea. Then I will discuss the meaning of freedom of conscience. After that, I will present conscious objection as a form of resistance for peace. And then I will examine the 2018 Korean Constitutional Court decision. And continue, I will also talk about alternative service system and its challenges. Finally, I will conclude with the idea of the right to live in peace. And I will introduce a new perspective based on recent events in South Korea. Okay, just some slide pass. First, let us look at the current system in South Korea. Traditionally, conscious objections, meaning refusing military service before enlistment. In other words, it means refusing to become a soldier from the beginning. This refusal is usually based on religious or moral beliefs. And then, so just a back slide. Then, after the 2018 court decisions, this right was officially recognized. Today, it is considered a legal right. However, objectors must perform alternative service instead. So, the system mainly focuses on what we call today total objection. However, there is another important issue. This is the selective conscientious objection. This refers to refusing a specific war or a military order. For example, a soldier may refuse overseas deployment, or a soldier may refuse a particular operation. Okay, but in South Korea, this is not recognized. Instead, it is punished as insubordination. So, the current system protects conscience only before enlistment. This is a very important limitation. Okay, then next slide. There is also a philosophical debate. If objectors are considered consciences, does that mean soldiers are unconscious? This paradox reveals the complexity of the concept. Conscience has both a general moral meaning and a constitutional meaning. Today, motives for objection have diversified. They include pacifism and feminism, professional ethics, and anti-war activism. This indicated that a conscious objection is no longer limited to religions. Instead, it is reflect broader social and ethic currents. From this perspective, conscious objections can be understood as a resistance for peace. Its essence is the right not to kill and the right not to become a perpetrator. This connect to the idea of the right to live in peace. Therefore, guaranteeing a conscious objection may contribute toward deterrence. Okay. Okay, next slide. So now let me move to the most important turning point in South Korea. This is the 2018 decision of the Constitutional Court. Before this decision, there was no alternative service system. So many conscious objectors were punished and imprisoned. In fact, South Korea had one of the highest numbers of imprisoned objectors in the world. Maybe I remember for year almost 600 people, maybe. And however, in 2018, the court ruled that this situation was unconstitutional. The court said that the law was incomplete. This was because it did not provide any alternative service. As a result, the government had to introduce a new system. This decision marked a historic change in Korean constitutional law. After this decision, South Korea introduces an alternative service system. An alternative service commission was created. This commission reviewed applications from objectors. However, the system still has many problems. First, the duration is 36 months. So now Korean soldiers' duration is 18 months. So it is a double, right? Second, the work is limited to constitutional factors. Objectors must live in dominated and follow strict rules. Because of these conditions, many scholars criticize this system. They say that it is too strict and even punitive. And then there are also a constitutional concern. The Constitution Court said that conscience must be deep, certain, and sensitive. This means individuals must prove their beliefs. However, this raises a human rights question. For example, how can the state measure conscience? Can the government judge personal beliefs? Some critics say this may violate human dignities. It may also limit freedom. Another issues in the review process. Some applications say the interviews are very strict. They also say the process is invasive. They are asked detailed personal questions. These questions include religion and lifestyle. This can cause philosophical pressure. It may also lead to discrimination. And so some scholars argues that military personnel should not join the commissions. This is because objectors must be protected from military influence. The goal should be respect, not suspicion. So here and then. And so I will be, so here, so I will be introduced two scholars' opinions. First one, Toshihiro Yamaguchi he said notes that while Germany explicitly guarantees this right in its basic law, most other countries have not reached that stage. And second person is Oh Dong-suk. He from Aju University in South Korea. He said, criticizes the current alternative service for being controlled by the Ministry of Defense and called for a human rights based approach rather than purely legalistic one. Okay. So so next one is okay. Oh, this right. Now let us reconsider the military system itself. Compulsory service may involve forced labor. It often includes low wages. It also restricts freedom. Soldiers may lose basic rights. For example, labor rights and freedom of expression. Even personal autonomy may be limited. From this perspective, conscription can be structural violence. This is not only a Korean issue. It is a global issue. And so, we need a new perspective. We should move beyond the simple debate. So this debate is between contribution and volunteer system. Instead, we should question the military first mindset. This mindset prioritizes military solutions. It often ignores diplomacy and peace. Guaranteeing a conscious objection can change a society. It can lead a more peaceful paradigm. In conclusion, I would like to emphasize one idea. This is the right to live live in peace. Okay. Some scholars say this should be a fundamental right. So, just I was said, for example, Germany guarantees this right. However, many countries have not reached this level. South Korea also needs a further reform. This is necessary to protect both conscience and peace. So, there are several future takes. First, the 36 months duration should be reconsidered. Second, the commission should be reformed. Third, the scope should expand. This includes selective objection. This can prevent war crime. It can also protect soldiers' moral responsibility. We also need research East Asia. This includes reducing military tensions. Okay. Finally, I would like to present a new perspective. As you know, in December 3rd, 2024, martial law was declared in South Korea. Many soldiers were deployed to the National Assembly. However, many showed a passive responses. Okay, responsive. So it means they followed orders but avoided violence. They did not use force. Even so, they had the authority. This behavior can be seen as a selective objection. Okay. So so this is right. So at the time, the key logic is soldiers follow the president's order to enter the National Assembly. However, they intentionally refrained from taking aggressive action or using forces. So therefore, this should be viewed as a selective refusal based on conscious rather than simple insubordinations. Okay. Expanding this concept may contribute to peace in East Asia. East Asia. So, in here, this raises an important question. So I will give to you. Should we punish such behavior, or should we recognize moral courage? In the future, we should build a system. So this system should protect both peace and conscience. Okay. So thank you very much for your attention. So it is my first time presentation in English. As I was just nervous. I'm sorry about that. Thank you.
Well, thank you so much, Shin. It was an excellent presentation and very clear, and those slides were very helpful, the PowerPoint. And so we really appreciate your contribution. I found it just fascinating. And Jiwan, could you interpret that for him?
Of course, I will. 교수님 감사 인사를 먼저 전하고요. 발표 잘 들리시죠, 교수님?
네네네.
네, 발표 완벽했고 명확했다고요. PPT 슬라이드도 도움이 많이 됐고, 다시금 발표에 감사드리고 아주 흥미로운 발표였습니다. Okay, I've done.
Thank you, Shin, for explaining conscientious objection in South Korea in the context of achieving peace and preventing war.
아시아의 평화랑 전쟁 방지의 측면에서 한국의 양식적 병역 거부에 대해서 잘 설명해 줘서 다시 한번 감사드립니다.
And also thank you for examining the concept of freedom of conscience and also the critical human right to peace.
평화를 위한 인권에 매우 중요한 양심의 자유에 대한 개념에 대해서 또 검토해 주신 점에 대해서도 감사드립니다.
Thank you as well for detailing different motives that people have for becoming conscientious objectors.
또 양심적 병역 거부를 선택하는 다양한 동기에 대해서도 자세히 설명해 주셔서 역시 감사드립니다.
And also for your proposals for reform in South Korea and the global ramifications of this policy.
또 이 정책과 관련해서 한국에서의 개혁 또 그리고 전 세계적 차원에서의 개혁에 대해서 새로 제안해 주신 그 부분도 역시나 인상적이었습니다.
One of our students has mentioned that how struck they were by the phrase that the right to peace is the right not to kill.
그리고 수강생 중 한 명이 죽이지 않을 권리에 대해 이 단어에 대해서 굉장히 충격을 받았다고요. 또 댓글에 남겨줬다고 언급했습니다.
Shin, I wanted, and also the right not to be a perpetrator.
네, 또 가해자가 되지 않을 권리에 대해서 언급해 주신 것도 네.
I wanted to clarify something. Did you say that aside from South Korea, only Germany has the right to conscientious objection?
한 가지 명확히 하고 싶은 점이 있는데, 한국이랑, 즉, 한국을 빼고는 독일만이 이제 양식적 거부의 권리에 대해서 양식적 거부 권리를 인정하고 있다. 양식적 거부권이 있다고 말씀하신 게 맞나요?
네, 뭐, 시간적인 제약도 있고 해서 제가 자세히 설명을 드리지는 못했지만, 이제 독일 같은 경우에 제가 알기로 독일 기본법이나 법률 차원에서 이제 명확하게 규정이 된 걸로 알고 있어서 그렇게 예를 들었습니다.
Yes, you're correct, and I couldn't explain, I couldn't elaborate more due to the time constraints, but the Germany has recognized this right as in the basic law, so that's why I've suggested the example of Germany.
Yes, here is a question. In Korea, is conscientious objection based solely on religious grounds, or are there secular people who are also eligible to be conscientious objectors?
질문이 하나 있는데요. 한국에서의 양심적 병역 거부가 종교적인 이유에서만 근거하는지 아니면은 또 다른 종교적 이유 외에 일반인 다른 이유로도 이제 군 병역 입대 면제의 사유가 될 수 있는지.
네, 결론적으로 말씀드리면 이제 종교적 이유만으로는 아닙니다. 통역해 주세요. 예.
네. So to say in one word, it is not only the religious reasons to accept as a conscientious objector.
통계적으로는 역시 종교적 이유의 양심적 병역 거부자가 많았습니다.
Of course, the statistics says the most of the conscientious objectors were the really has the religious reason.
하지만 이제 특히 21세기 들어서 이제 양심적 병역 거부라는 이제 이 개념이 한국 사회에도 이제 적용이 되었고요.
But since the 21st century, the concept of conscientious objector became to be prevalent in South Korean society.
종교적 이유뿐만이 아니라 이제 소위 말하는 이제 아까 전에 말씀드린 것처럼 이제 죽이지 않을 권리, 나는 이제 이 사람을 죽이는 총을 들 수 없다, 이런 소위 말하는 평화적 신념으로 순수한 종교와 상관없이 순수한 이제 평화적 신념으로서 이제 병역을 거부하는 사람들이 생겨났습니다.
So now the South Korean society has some people who are regardless of religion, who are insisting not to enlist the army because, for example, they have the so-called pacifism convictions, or they don't purely they don't want to grip or use weapons or machinery.
그렇게 이제 오늘날에는 다양한 이유로 이제 병역을 거부하는 사람들이 생겼고, 조금 전에 간단하게 설명드린 것처럼 이제 2018년 이후에 이제 도입된 대체복무제도, 이제 신청을 이제 하고 그런 이제 상황이 있습니다.
So there are many people who have the various reasons to be conscientious objectors. So after the 2018, yes, such people are they're applying to the alternative service.
Thank you for that. James, I would like to bring you into this discussion, and that is, besides the fact that there is no right to conscientious objection in the US, what are the grounds for conscientious objection? And before you answer that, can we have Jiwon translate that for Shin, please?
Sure. In the United States, conscientious objection functions in two contexts. One is in the active duty context for people that are currently in the military. The second one is in the event of a draft or military conscription. And I'll go ahead and I'll go ahead. So in both of
Let's
those,
let G1 translate that first.
Okay.
Yes. Okay.
이제 선생님, 교수님께 제가 메시지로 통역할 수 있다고 보내긴 했는데,
예, 지금 이제
토론,
자막으로 보고 있어요.
네,
보고는 있어요.
네, 토론에 이제 그 전 발표자를 같이 토론하고 싶다고요. 그 양심적 거부권이 없다는, 그 미국이 없다고 했는데, 이제 미국에서의 그 양심적 거부에 대한 근거는 이제 뭔지 이제 그 질문을 하고 있어요. 그래서 지금 그 답변하기를, 어, 이제 지금 현역병 사람들이랑 또 그러니까 징집된 사람들 두 가지 케이스에 따라서 나눠서 하고 있는데, 네, 지금, 네.
and then in both of those contexts, the criteria are fairly similar, what must be proven. You must prove that you are opposed to all wars, number one. Secondly,
Let's stop there and let him
Okay.
translate. Okay.
네, 이렇게 끊어서 가려나 보네요. 어쨌든 좀 다른 상황에 대해서 설명을 하고 있는데, 지금 입증을 해야 되는데, 일단 하나는 본인이 이제, 양심적 거부 중에서 뭐 어떠한 모든 전쟁에 다 반대를 해야 하는 상황이다라는 것을 이제 증명을 할 수 있어야 되고요.
Secondly, the person must object either on religious grounds or from a place of deep conscience that functions similarly to how a religious person would think.
종교적인 이유나 아니면 그와 비슷한 또 다른 어떤 양심적인 이유로 인해서 그것을 반대해야 됩니다. 거부해야 됩니다.
The third thing is that the person must be sincere, meaning that conscience is their primary motivator for not wanting to serve in the military.
그리고 세 번째로는 이 진정성이 있어야 하고요. 단순히 군 입대를 안 가고 싶어서 거부하는 그런 게 아니라 진짜 양심에서 비롯된 진정성이 있어야 됩니다.
And finally, the beliefs must have crystallized or become fixed in nature. For people who are active duty, it has to have happened after they enlisted. For people who are being drafted, it would have to have happened before the draft, before they were called up.
그리고 하나는 신념이 단단해야 되고, 그래서 징집되기 전에, 그러니까 군에 들어가기 이전부터 어떤 형성되어 왔던 것이어야 됩니다.
And that's it.
Thank
네.
you. Thank you. And we have a question. In the US, it's the military decision maker who decides on sincerity. Who makes that decision in South Korea?
질문이 준 게 이제 미국에서는 진정성에 대해서 어떤 결정을 누가 내리느냐인데, 그럼 한국에서는 이것을 누가 결정하는지, 네, 질문이 있습니다.
네, 예, 마찬가지로 조금 전에 제가 발표에서 대체역 심사위원회에 관한 이야기를 조금 드렸는데요.
So during my presentation, I mentioned the Alternative Service Review Committee.
뭐, 논란이 참 많은 부분이긴 합니다만은 이제 병역 거부자들이 이제 병역을 거부해서 대체역을 신청을 심사위원회에 하면
Yeah, so I should say it's very controversial in our society. So when the conscientious objectors apply to the review committee,
이제 본인들이 신청을 해서 이제 심사위원회에서 심사를 합니다.
then the committee investigates and evaluates the applicants.
그 심사위원회가 결정을 한다 이렇게 볼 수가 있겠는데,
So I can say that committee decides whether the applicants are really sincere or not.
근데 이제 그 심사위원회가 그 신청자들의 양심의 진정성을 과연 이제 정확하게 심사한다고 할 수 있는가 하면 그렇게 보기도 어렵습니다.
But we have doubt that this committee really has a competence to judge the sincerity of the applicants.
아까 발표에서 말씀드린 것처럼 이제 여러 가지 이제 질문들을 이제 하는 경우가 있는데,
It's because sometimes the committee makes many relentless questions.
하나만 예를 들자면 이제 당신은 그 총으로 쏘는 게임을 해본 적이 있느냐라고 질문을 한다고 하면,
So for instance, the committee could ask that have you ever played the how can I put this? The game using a gun? I mean the online game with the mobile games with the weapons.
그러면 해본 적이 있다고 그러면 당신이 말하는 건 거짓말이다 이렇게 판단을 한다고 들었습니다.
If the applicant said yes, that the committee rejected their applications. Oh, you're not sincere in your convictions.
만일에 그렇다면 그렇다고 한다면 이제 당신이 말하는 이제 총을 들 수 없다. 그거는 거짓말이다. 이렇게 판단을 해버립니다.
Yes, the committee decides that your conviction, which according to which you're unwilling to use the guns, is just a lie.
게임하고 현실은 다른데 말이죠.
Of course, we should note that the reality is very different from the online games.
예, 다른 경우에도 제가 직접 이제 병역 거부자들하고 이제 인터뷰를 해본 적이 있는데 그들로부터 그런 대답을 듣기도 했습니다.
So once I have interviewed the conscientious objectors, I've heard.
네, 일단 여기까지 하겠습니다.
Yeah, I've heard such their experiences. Yeah, that is my answer.
Thank you so much, Shin. And I wanted to just point out a comment from one of our task force members who was really struck when you said the right to conscientious objection is predicated on the right to peace.
우리 하나 언급하고 싶은 게 우리 TF 성원 중에 한 분이 말씀하신 내용이 교수님께서 평화의 권리에서 기반한 그 양식적 거부권에 대해서 이제 설명해 주실 때 깊은 감명을 받았다고요.
Thank you so much to our esteemed faculty, Tristino, Chantal, James, and Shin. You were all terrific. To our administrator and the interpreters, as well as the People's Academy Task Force. The next program of the People's Academy of International Law, maybe we should just translate that, Jiwon. First of all, the thank you.
통역 드릴까요? 네, 이제 마무리하려는 것 같은데, 이제 오늘 발표해주신 우리 교수진 여러분들이랑 이제 통역하신 분들, 그리고 민중법 아카데미 TF팀에게 감사 인사를 전하고, 다음 프로그램을 소개하려고 하고 있었어요.
And the next program of the People's Academy of International Law will be How to Resist Imperialist Attacks on International Law, scheduled for March 17th.
졸음이 한 시간이군요. 네, 이제 다음 주제는 이제 3월 17일에 예정돼 있는데요. 국제법에 대한 제국주의의 어떤 침해, 국제법 침해, 국제법 공격에 대해 저항하는 방법에 대해서 다룰 겁니다.
And our faculty for that program will include Edre Olalia.
네, 다음
Camilo. Yeah, go ahead.
I'm sorry for interrupting.
No, go ahead.
Yeah, thank you. 네, 다음 이제 교수진은 이제 그 에드가랑 이제 올리에가 될 텐데요.
Camilo Eduardo Umaña Hernandez and others.
네, 들으신 대로 이제 카밀라, 에두아르도, 마니아 그리고 다른 분들이 참여할 예정입니다.
You will receive more information soon. Thank you for coming and see you then.
네, 곧 정보 더 받으실 거고, 네, 다음에 뵙겠습니다.
That's it. Bye-bye. Thank you so much, everybody.
Thank you very much.
Thank you.